Hello, and welcome to this Taylor Wessing webinar, Patent Infringement by Equivalence, New UK Law and Insights from Germany and the Netherlands. My name's Chris Thornham. I'm a patent lawyer from Taylor Wessing in the UK, and I'm joined by my patent colleagues and speakers. They are James Marshall, also from the UK, Christoph de Costa from Germany, and Wim Maas from the Netherlands. The webinar was prompted by the recent UK Supreme Court decision in Actavis against Eli Lilly, which created new UK law on infringement by equivalence. Patent work is often multi-jurisdictional. We work with our colleagues across European jurisdictions, helping clients navigate different national practices, procedures and laws. The webinar brings together some of our European patent team to explore the issues. So here's an agenda for the webinar. First, I'll address some background on infringement by equivalence. I'll then address the new UK law following the Actavis and Eli Lilly decision in the UK. Next, James Marshall will talk about how the UK law has changed. Christoph de Costa will then provide German insights on the law of infringement by equivalence. He will also comment on the parallel Actavis and Lilly case in Germany. And then finally, Wim will speak. He will address the law in the Netherlands. He'll also draw some comparisons between the approaches in different countries. We'll then conclude taking questions if there's time. We would welcome questions and feedback. So for questions, there's a Q&A box in the corner of your screen. If you do wish to submit questions, please do so, and we'll try to answer them at the end of the presentation part of the webinar, or offline afterwards, depending on time. To provide feedback, please do complete the survey. It would be greatly appreciated. So, I'll start now the detail of this webinar, first addressing some background on infringement by equivalence. So, the starting point for the discussion is the European Patent Convention, the EPC. Participants in the EPO are signatories to the EPC. Article 69 is entitled Extent of Protection. Article 69(1) provides that the extent of protection conferred by a European patent or application shall be determined by the claims. Nevertheless, the description and drawings shall be used to interpret the claims. So, in addition, there's a protocol on interpretation of Article 69. This is an integral part of the EPC. It only has two parts, and it's set out in full on the slide. So Article 1 of the protocol sets out general principles. You have the full text there, and it first describes two extremes: strict literal meaning of the words in the claims, or claims serving only as a guideline. Article 1 requires a middle way, which combines fair protection for patentees and reasonable certainty for third parties. Article 2, that you see there on the slide, addresses equivalence. It was added in EPC 2000 revisions that came into effect in 2007. It requires that due account shall be taken of any element which is equivalent to an element specified in the claims. So there we have equivalence expressly called out, and UK judges had taken the view that the UK law was compliant with that requirement. Having that background in mind, let's now look at the new UK law arising from Actavis and Lilly. First, some facts about the case. The patent claimed a combination of Pemetrexed disodium with vitamin B12 for the prevention of growth of tumours. For those who don't work in the life sciences, that's almost all we need to know about the technology. During prosecution, there is an important point to mention. The examiner had insisted on limiting the claim to the sodium form of Pemetrexed, as this was the textual support in the example in the description. So patent attorneys joining us today will recognize this as a common situation. The applicant seeks a generalized claim, in this case Pemetrexed, without specifying the counterion, but the examiner requires something narrower based on the specific textual support. So let's move on a few years. We have then in the litigation, Actavis sought declarations of non-infringement in the UK. It was not challenging validity. The focus was on the claim wording Pemetrexed disodium. The claim requires Pemetrexed with a sodium counterion. And the proposed Pemetrexed products have a different counterion, e.g. potassium. The lower courts, that's at trial and in the Court of Appeal, said there was no direct infringement. They construed the claim and concluded that the proposed products didn't fall within the claim language. The Supreme Court, that's the top court in the UK, said there was direct infringement. In the UK, we operate a case law precedent system, so lower courts, trial and appeal, are bound to follow the Supreme Court's approach to questions of infringement. So before we turn to the next slide to look at the approach taken by the Supreme Court, I should give you one or two other pieces of background. Lord Neuberger is the president of the Supreme Court. He gave the decision in Eli Lilly that we're going to discuss further. The others agreed. There was no dissenting opinion. Now, Lord Neuberger didn't start out as a specialist patent practitioner before becoming a judge. However, he has experience of hearing patent cases at trial and on appeal. One of the most notable patent cases he tried as a judge was Kieran Amgen against HMR and TKT, and that related to a recombinant erythropoietin product. That case went all the way up to the top court, the House of Lords at the time. And that House of Lords decision set the law on patent construction infringement by its 2004 decision. So Neuberger certainly does have experience of patents, and the leading case actually he was involved in. So if we now move to a discussion of what he said in the Actavis and Eli Lilly decision, he gave the judgment, as I've noted, and the slide there quotes from paragraph 54 of the decision, with some emphasis added. Let me read it. In my view, this is Neuberger, a problem of infringement is best approached by addressing two issues, each of which is to be considered through the eyes of the notional addressees of the patent in suit, i.e. the person skilled in the art. Does the variant infringe any of the claims as a matter of normal interpretation? If not, does the variant nonetheless infringe because it varies from the invention in a way or ways which is or are immaterial? So two issues. He then went on and gave guidance at 56 on the approach to be taken on issue 2. He said the task is not, on question 2, it is not identifying what words the claim mean to the skilled addressee. That's already been done. What you must consider is how far the scope of protection should extend beyond that meaning. That is the point of the second issue. So, the Supreme Court's approach is not confined to the facts of the case or the chemistry or the life sciences sector. I just ought to emphasize the approach applies to all technology. So on this second issue of immaterial variance, at paragraph 66, the decision indicates 3 questions that must be asked. Let me read it. First, notwithstanding that it is not within the literal meaning of the relevant claims of the patent, does the variant achieve substantially the same result in substantially the same way as the invention? i.e., the invention or the inventive concept revealed by the patent. Okay. So that test is in contrast to the literal meaning of claims. Looking at that variant is not a textual analysis. It requires looking at the result and the way that the result is achieved. Now let's look at the second question. Would it be obvious to the person skilled in the art reading the patent at the priority date, but knowing that the variant achieves substantially the same result as the invention, that it does so in substantially the same way as the invention? So, you can see the text in red there. This imbues the skilled person with a knowledge that the variant works. That's more information than he might have at the priority date, and it does make it easier to satisfy this limb. Then we look at the third question. Let's assume that 1 and 2 have been satisfied. The third question. Would such a reader of the patent have concluded that the patentee nonetheless intended that strict compliance with the literal meaning of the relevant claims of the patent was an essential requirement of the invention? So it's contrasting with literal meaning and asking whether something is an essential requirement of the invention. Care is required on that word invention. If you take away a component of a device, it won't work. That doesn't necessarily mean it's essential to the invention. A variant may work, of course. One needs to think about whether it's essential to the invention. So, I now turn to the decision on the facts. First question was addressed as follows. The evidence was that Pemetrexed with a potassium counterion works in the same way as Pemetrexed with a sodium counterion. They work the same way, same results, satisfied. Second question. Now, it wasn't agreed that it was obvious at the priority date or the publication date that a potassium counterion would work in the same way as sodium. You know, science is empirical. You often have to try to find out and to know. However, for the purposes of this test, the skilled person is treated as knowing that the variant works. With that knowledge, it's obvious it works in the same way. So, step 2, satisfied. On the third question, the Supreme Court said the lower court of appeal had paid too much attention or emphasis on construing the words and not enough on Article 2 of the protocol. Remember, Article 2 says one has to have regard to equivalence. The Supreme Court considered the text of the description and concluded that the specification did not teach any relevance or importance of sodium, that the invention was Pemetrexed plus vitamin B12. So the use of a sodium counterion was not essential to that invention. And as the judge found, Lord Neuberger, he said there was no plausible reason why the patentee should want to limit to sodium. On that basis, he held that potassium was equivalent to sodium specified in the claim, therefore there was infringement. So, I've talked you through the principles and the application of them in the case. I'll now pass on to James Marshall, who will address how the UK law has changed as a result of this decision.
Thank you very much, Chris. Well, this new two-step approach of firstly asking whether the variant infringes as a matter of normal interpretation, and then, if not, asking whether the variant nevertheless infringes because it varies from the invention in ways that are immaterial. This is a very significant departure in the English law of infringement. It is certainly the most significant change on this topic in my 30-year career, and probably for quite a long time before that. Clearly, it's a development favourable to patentees and to the detriment of parties seeking to design around a patent. It potentially can come to the rescue of patentees in those cases where, with hindsight, the claim might have been drafted slightly differently so as to catch a party who is seeking to make use of the invention but avoid infringement by making relatively small changes. So how has the law changed? Well, the striking aspect which Chris alluded to a moment ago, is that it is absolutely clear that Lord Neuberger intended the second question and involves not merely identifying what the words of the claim would mean in context to the notional addressee, so beyond literal, but also considering the extent to which the scope of protection afforded by the claim should extend beyond that meaning. Chris has already referred to those words, but I thought it was worth re-emphasizing them. They come from paragraph 56 of the judgment. So the idea of finding infringement outside the wording of the claims is a very different situation from that which we have all been used to in the UK for a long time. So let me just remind you of how infringement has been approached by the UK up until now. Previously, the English courts have sought to avoid unfairness to a patentee by not adopting an unduly literal approach to claim interpretation, like the courts in many jurisdictions. But the English courts have until now stopped short of doing what the US courts, for example, have done, namely having a doctrine of equivalence. Indeed, in the last third instance decision on claim interpretation scope of protection, this is the Kieran Amgen case that Chris was referring to, we were told very plainly by the House of Lords, that's a precursor to our current Supreme Court, that the doctrine of equivalence was not English law. To quote from Lord Hoffman, who gave the leading judgment in that case, he said, "We have Article 69, which, it seems to me, firmly shuts the door on any doctrine which extends protection outside the claims." Indeed, Lord Hoffman expressed a concern that once the monopoly is allowed to use his words, escape from the terms of the claims, it's not easy to know where the limits of the monopoly should be drawn. So instead of a doctrine of equivalence, the English courts have, in the last 35 years at least, adopted a so-called approach of purposive rather than literal construction or interpretation. In other words, it's a question of interpretation which takes into account the inventor's purpose. In the Amgen case itself, the English House of Lords explained that the principle that gives both fair protection to the patentee and a reasonable degree of protection for third parties, as required by the protocol to Article 69, was as follows. What they said was, the question was always what the person skilled in the art would have understood the patentee to be using the language of the claim to mean. There are other passages throughout the judgment in the Amgen case that make it abundantly clear that the position up until now has been that the question of whether or not a product came within a patent was purely a question of claim interpretation, or claim construction. In other words, interpretation of the patentee's intended meaning from the words that he has used, interpretation of the patentee's intended meaning as to the scope of his monopoly, intended scope of his monopoly. And in several cases, the judges had said, it emphasized that the specification is a unilateral document in words of the patentee's own choosing. The words are usually chosen on the basis of skilled advice, and so on. The language chosen is usually of critical importance, and so on. So a well-known earlier example of the purposive construction is the 1982 third instance Catnip case, which is very well known, in which the limitation vertical in a claim directed to a door lintel, was held to cover a lintel where the back plate of the box structure was just a few degrees off precisely 90 degrees, so as to make no difference as to how the lintel actually worked. The point being that the patent was directed to persons in the building trade and not geometers. A little later in the Improver or Epilady case, there was a stark illustration of the fact that the English court's approach to scope of protection was interpretation only, and on that occasion, famously, the English court's decision differed from those in Europe, and holding that the term helical spring took the product outside the claim, as it was simply not capable, even in the context in which that term was used, to cover a rubber slitted rod. Chris mentioned a moment ago the so-called improver questions that were formulated in that case and were applied in the UK pretty religiously during the 90s and the early noughties as a means for determining infringement, and has been said by our courts to be in line with the protocol to Article 69. They actually became slightly less prominent following the Amgen case in 2004, where it was said that those improver questions were just guides rather than legal rules, which may in appropriate cases help to decide what the skilled person would have understood the patentee to mean. So the overriding criterion was what the skilled person would have understood the patentee to mean. Now it seems, as a result of the Actavis case, new life has been breathed into these questions, albeit they're still described as guidelines and, as Chris has emphasized, modified in a significant way as a mechanism for addressing the second question posed by the Supreme Court, the fundamentally new question as to how a variant might infringe, even outside the scope of the claim as, quote, normally interpreted. In fact, the Lord Newberger and Actavis made it plain that the third improver question can be satisfied even though no sensible reading can cover the variant. So we're talking about situations here where there is a potential for determination of infringement under our new law when the result previously would have been non-infringement, as indeed highlighted by the fact that the Court of Appeal in Actavis, applying traditional English purposive construction, found no infringement. Before handing over to Christoph and Wim, who will discuss the German and Dutch positions, I will just put forward two thoughts and mention one other aspect of the decision, three questions in total. Firstly, the Supreme Court was not considering validity, and no mention was made of it. The question therefore arises as to whether, when considering lack of novelty or lack of inventive step attacks, the prior art should be compared with the invention according to the claim as normally interpreted only, or be compared with the scope of protection offered by the patentee when taking into account variants according to the new guidance, even if they fall outside the claim when normally interpreted. As I say, not discussed by the Supreme Court, but to my mind the answer must be the latter. You must consider the same scope of protection for both infringement and validity. Otherwise, you have the possibility of someone being found to infringe a valid patent when they're doing no more than work the prior art. That is, or ought to be, a fundamental principle of patent law. Second, we may expect to see a larger number of declarations of non-infringement in the UK, as if anything, it was going to become a little more difficult to predict with confidence whether a particular patent or process infringes. By statute in the UK, it is possible to initiate a claim before the courts for a declaration of non-infringement even where the patentee has not asserted the patent. So we may expect to see a larger number of applications for declarations of non-infringement. The third point I'll just deal with very quickly, but it needs to be mentioned, and that is reference to the prosecution files. And this was dealt with by the Supreme Court in Actavis as to when, in the circumstances when that might be done. I'll just quickly go through that slide that summarizes the position. House of Lords in 2004 in Kieran Amgen discouraged the use of file history as an aid to construction. Patent meaning shouldn't change depending on access to the file, and to use their words, life is just too short for the limited assistance it can provide. By contrast, Now, the Supreme Court in Actavis proposes a skeptical but not absolutist approach. So you may consult the file now where the point at issue is truly unclear if one confines oneself to the specification and claims, and the contents of the file unambiguously resolve the point, or if it's contrary to the public interest for the contents of the file to be ignored. For example, if the patentee has represented to the European Patent Office, he is not seeking to contend that the patent, if granted, covers a variant which he now claims is infringed. And actually, on the facts of Actavis, the Supreme Court said there was no reason to depart from their preliminary conclusion of infringement, even though the examiner's stance is questionable. Even if it was right, the whole point now of the doctrine of equivalence is it entitles the patentee to argue that protection extends beyond the ambit of the claim normally construed. So to answer the question just posed a few moments ago, I think we will definitely be referring to the prosecution file when we do infringement analyses to see whether there's any material on the file that might qualify under the limited circumstances mentioned by the Supreme Court where it may assist, but the occasions when it will be relevant are not likely to be frequent. And generally speaking, the prosecution file will be a relatively quick exercise to see whether or not there is any material that may be important. So I'm not anticipating a significant extra burden. So I'll now hand over to Christoph, who will explain the position in Germany.
Yeah, thank you, James. It seems that despite Brexit, at least the UK patent courts are still looking at continental Europe. The recent UK decision is certainly an attempt to harmonize the UK approach to the determination of the scope of protection of a patent with continental European approach, at least with the German approach. The German approach to the doctrine of equivalence has always been very similar to the approach that the UK Supreme Court now adopted. And basically, a three-step test has been performed to determine the scope of a patent claim in Germany since at least 30 years. The approach is illustrated in the present slide. 3 steps. The first step, claim construction, red circle. The claim has to be construed on the basis of the claim wording and the specs of the patent. Not the literal meaning of the claim wording is crucial, but the technical understanding of the wording by the person skilled in the art, reading the specifications. An attacked embodiment that is within the technical meaning of the claims, red circle, infringes the claim literally. Second step, embodiments that are outside of the literal meaning of the claim, so-called variants, yellow circle, can still be infringing under the doctrine of equivalence if they meet the 3-question test that has been applied in principle since many years in Germany. Third step, Fornstein defense concerning validity. If such variants, yellow circle, are closer to certain prior art than the claimed subject matter, red circle, and thus anticipated by or obvious in view of this prior art, they cannot be part of the scope of protection of the claim. Such variants have to be carved out under the so-called Fornstein defense in Germany, also known as Gillette defense in other continental jurisdictions. The resulting scope of protection in Germany is the red and the yellow circle, but not the blue part. This slide shows the German scope of protection test for variants, so embodiments outside of the literal meaning of the claim. The 3 requirements that have to be met in order to assume infringement under the doctrine of equivalence in Germany are pretty similar to the questions that the UK Supreme Court has now adopted. First requirement, same technical effect. The variant must achieve, at least to a substantial degree, the same technical effect which is, according to a patent, achieved by the claimed solution. Second, requirement, obviousness. The expertise of the person skilled in the art must enable him to discover the variant as technically equivalent without inventive effort. And third requirement, legal equivalence. The thought process that the person skilled in the art has to perform in order to discover the variant must be oriented on the meaning of the teaching protected in the claim. If the answers to all these questions are yes, the defendant can still rely on the Formstein defense in order to argue non-infringement. The defense is very difficult and has not been successful very often in Germany. The defendant has to present prior art that is specifically relevant to the variant without questioning the validity of the claimed subject matter. If the prior art is relevant for the claimed subject matter and not only for the variant, the defense cannot be raised in infringement proceedings, but only in nullity proceedings due to the bifurcated system in Germany. There is, of course, plenty of case law on how to apply the three questions in Germany, but today I will only focus on some general basic guidelines with regards to the questions. The first requirement is that the variant substantially has the same effect advantage as the claimed solution. Of course, the broader the advantages effects can be defined, the broader the scope of protection. However, the relevant effects have to be determined on the basis of the patent specification, first requirement. In addition, German courts have emphasized that not only the overall effect of the invention is relevant, but also the sub-effects of the specific feature that is not realized by the attacked variant. For example, the overall effect of the claimed subject matter, for example, a snow chain, can be the user-friendly improvement of the handling of the device. The sub-effect of the relevant feature that is subject to the variant might be more specific, for example, a certain mechanism that is less likely to ice up. All these specific sub-effects of the specific feature must also be achieved by the variant. However, it is not required that these effects are achieved to 100% as long as they are achieved to a practical relevant extent, meaning that, for example, so-called less advantageous variants may still meet requirement 1. The second requirement is that the variant and its effect need to be obvious for the skilled person in view of the teaching of the patent. The German courts apply the usual inventive step test for this requirement. This test thus differs from the UK question 2 that is shown again on the slide. Please see especially the red part, which, as Chris already explained, allows some hindsight. Hindsight is not allowed in Germany. Actually, the UK Supreme Court discussed the test of the German courts in its decision, but thought that it was too strict. The judge stated, if the variation represents an inventive step, while it may render it less likely that the patentee will succeed on the second reformulated question, I find it hard to see why that alone should prevent the resultant variant from infringing the original invention. But he also concludes saying, having said that, it should be added that the German version of the second test will, I suspect, usually produce the same result as a reformulated second question in UK. Both the UK and the German courts agree that the relevant point in time for the obviousness test is the priority date. However, they also agree that infringement by equivalence is not limited to foreseeable variants only. If a new technique becomes available after the patent was granted, which makes available an obvious variant, it would be harsh and contrary to fair protection for the patentee to deny him the right to attack those. Or as the Court of Appeal Düsseldorf put it in a recent decision, in such a case, the variant falls into the lap of the infringer. The third question is about legal equivalence. The test question in Germany is whether the thought process that the person skilled in the art has to perform in order to discover the variant was oriented on the meaning of the teaching protected in the claim. That is rather general. The Federal Court of Justice has further explained the requirement in the recent Pemetrexed decision as follows. The person skilled in the art must not understand that the strict compliance with the wording of the claim is an essential requirement of the claimed invention. This sounds very similar to the corresponding UK question. The third requirement is usually the one on which close cases turn in Germany and has produced a lot of rather fact-specific case law in Germany. However, the following facts and arguments can be used in favor of a rather strict compliance with the wording of the claim. First, numerical values. Numerical values are precise by nature, as the German Federal Court of Justice said, and thus allow the assumption that they were consciously selected by the patentee to limit the claim. Secondly, the waiver idea. According to the Federal Court of Justice Occluder decision from 2014, a waiver can be based on the specifications. Variants that are specifically disclosed in the specs but not claimed are disclaimed. According to the Pemetrexed decision, a waiver may also be based on the file wrapper. That is still unclear. Variants that were initially disclosed but later on excluded from the claim and the specs during prosecution in order to distinguish the claimed invention from the prior art might be disclaimed. The Federal Court of Justice has opened the door here for file wrapper estoppel, which was not allowed in Germany until now, but still refuses a definite statement in this regard. So the situation is similar as explained by James for the UK. And the third idea for a narrow construction, teach away of the patents. If the claim solution is based on a principle emphasized by the specs and the variant applies another principle, the variant is outside of the claim, even if obviously achieving the same effect. How did these tests apply in the German Pemetrexed case? Actually, the case was a ping-pong game, not only between the instances in Germany, but also between the courts in Germany and UK. Very qualified courts were struggling with the infringement question and came to different results again and again, showing how difficult the test is to apply in a concrete case. The course of events in Germany, just very briefly, the district court in Düsseldorf came to the conclusion that there is equivalent infringement of the Pemetrexed patents by the dipotassium salt of Pemetrexed, because the answer to all three requirements and questions of the equivalence test was yes. The Court of Appeal Düsseldorf disagreed. There's no equivalent infringement because at least the answer to question 3 is no. The Federal Court of Justice again disagreed and said the answer to question 3 is yes, so that the Court of Appeal Düsseldorf has to check questions 1 and 2 again. The case was sent back to the Court of Appeal in Düsseldorf. The case is currently pending before the Court of Appeal in Düsseldorf, and the court has ordered an expert opinion on question 2, obviousness of the dipotassium salt in view of the patent and the disclosure of the disodium salt. The decision is to be expected in 2018, and we will see whether that again will be appealed to the Federal Court of Justice. What are the learnings in Germany from that case? The first learning concerns the third requirement of equivalence, on which the Court of Appeal in Düsseldorf and the Federal Court of Justice disagreed. The Düsseldorf Court of Appeal applied the waiver idea from the Federal Court of Justice decision in Occluder and argued that the patent discloses a class of antifolates, but just claimed the disodium salt of Pemetrexed, thus disclaiming all other antifolates and salts. He also argued that the prosecution file confirms that the claim was limited from Pemetrexed to Pemetrexed sodium due to an added matter objection of the examiner, and that also this could be considered to be a waiver. The Federal Court of Justice disagreed and stated a waiver can only be assumed with regard to variants that are specifically disclosed but not claimed. And since the potassium salt of Pemetrexed was not specifically disclosed by the specifications, it was not disclaimed. He added it might be possible to assume a waiver on the basis of the prosecution file, but only if the limitation was made to distinguish the claim from the prior art, and not if it was made for formal reasons, as in this case, it was made for added matter concerns. Overall, as the Supreme Court in the UK, the Federal Court of Justice saw that the inventive concept of the invention was a combination of Pemetrexed with vitamin B, so that the specific salt was not essential for the claimed invention. The second learning might concern the second question. The Court of Appeal Düsseldorf might, if necessary, now decide whether the German stricter approach to the second question, as explained, is maintained, or whether the more generous approach of the UK Supreme Court is now also adopted in Germany. A short summary from a German point of perspective. First point, harmonization of the law in UK and Germany. The general approach to determine the scope of protection of a patent claim is now very similar in Germany and UK. It will be easier now to discuss infringement or non-infringement with my UK colleagues. The overall scope of protection has certainly been broadened, as James already mentioned, by the recent Pemetrexed decision in both UK and Germany. What are the remaining differences? As already explained, there are slight differences with regard to the second question and the question whether hindsight should be allowed for the obviousness test or not. Then certainly implementation of the approach. The case law in Germany shows that the harmonization of the approach does not mean consistent decisions yet. The devil is in the details, and we have to see how the UK courts approach the test in future. Last point, validity questions. In Germany, the defense, Ormstein defense, is very limited due to the bifurcated system. That is different in non-bifurcated systems as in the UK, where in general the use of squeeze arguments is much easier, as James already mentioned. With these remarks, I conclude the German session, and I will hand over to Wim and the Netherlands.
Thank you very much, Christoph. The developments in the UK and Germany are also very interesting for the Netherlands, and I think it's safe to say that there are still some fundamental dogmatic differences between our countries. In the Netherlands, the latest Supreme Court judgment is in the case of Bayer against Sandoz, and to better understand the ruling of the Supreme Court, I will give you a short summary of the facts. Bayer is the holder of 2 European patents for a method of preparation of drospirone, the active ingredient in Bayer's contraceptive pill sold under the brand name Jasmine. Sandoz offered for sale a generic version of Jasmine, and Bayer initiated preliminary injunction proceedings against Sandoz, in which Sandoz only defended itself by raising an invalidity defense. Sandoz at the time had no infringement defense. The invalidity defense of Sandoz was dismissed by the PI judge, and the patents of Sandoz of Bayer were found valid and infringed. An injunction was granted. Sandoz, however, did not leave it at this and started looking for a workaround. In their view, they also found one. Instead of using the metal salt ruthenium as a catalyst, as claimed in the first patent, Sandoz applied an organic compound named Tempo. Furthermore, Sandoz did not separate water by adding PTSA, as claimed in the second patent, but with a weak base named pyridine and water. Bayer again sued Sandoz for infringement in PI proceedings, and Bayer's view is that the new Sandoz method is equivalent to the claimed method and therefore also infringing Bayer's patents. The PI judge, however, dismissed the claims of Bayer. Also, the Court of Appeal did not rule in favor of Bayer. And with respect to the first patent, the Court of Appeal ruled that the skilled person would assume that Bayer had knowingly chosen to claim ruthenium salt and therefore that the scope of protection does not extend to the use of a variant, tempo. With respect to the second patent, the Court of Appeal decided that the skilled person would understand the patent to be limited to only the use of the specific acid PTSA, which would exclude from the scope of protection the use of other products such as base pyridine with water. And Bayer appealed this judgment to the Supreme Court. And as you might know, the Dutch Supreme Court can only decide on legal questions and not on facts. The question whether a variant should be considered an equivalent is purely factual in many cases, and that leaves the Supreme Court to only rule on whether the Court of Appeal applied the right interpretation of the law. Bayer was of the opinion that the Court of Appeal applied the wrong legal criteria to protect equivalence. In his advisory opinion, the Advocate General von Persum advised the Supreme Court to again dismiss the claims of Bayer. Von Persum provides a very good overview of the Dutch approach to equivalence, and is also taking into account the approaches of the US, Germany, the UK and France. Also, the Supreme Court explains the Dutch approach in detail, also referring to earlier Supreme Court judgments. So what do we learn from this judgment? First of all, the Supreme Court in the Netherlands applies a contextual interpretation of the claims, in which the idea behind the invention is a viewpoint, as is the literal meaning of the claims. And these two viewpoints are the two extremes referred to by the protocol, which should be avoided. One should seek a balance between the honest protection for the patentee as well as a reasonable degree of legal certainty for third parties. And the Supreme Court again confirms that establishing the idea behind the invention is important to avoid a purely literal interpretation of the claims, which could deny a reasonable protection to the patentee. And by explicitly confirming that the idea of the invention still remains important as a viewpoint, the Supreme Court tries to convey the impression, at least, that his case law remains consistent over time, but I personally see a trend that it has become much more difficult to get protection beyond the meaning of the claims. That is a personal note from my side, but whether that is good or bad, of course, depends on whether you're a patentee or an alleged infringer. But in this way, it seems a bit different than the trend now in the UK and in Germany. The descriptions and the drawings are, as expected, of course, an important source to establish the idea behind the invention. All prior art referred to in the description or not could be of importance, since the perspective of the skilled person, with his knowledge of the prior art, is leading in applying a contextual interpretation of the claims. And in my view, this is the step in the Dutch contextual approach that creates the room to protect the equivalence. If, for instance, the idea behind the invention is broader than the literal wording of the claims, and there is no indication that the patentee knowingly limited the claims to a certain feature, the claims should be interpreted to also cover the equivalent feature. I will go to the next slide. Bayer tried to convince the Supreme Court that the Court of Appeal was wrong in ruling that the skilled person would assume that Bayer had knowingly chosen to claim ruthenium salt, and therefore that the scope of protection does not extend to the use of the variant tempo. And Bayer brought forward the opinion that protection for an equivalent can only be denied if there was a reasonable ground to assume that the patentee had knowingly renounced protection for an equivalent, and the Supreme Court did not follow this and ruled that the Court of Appeal applied the correct legal criteria. According to the Supreme Court, it was correct that the Court of Appeal took into account the contents of the patent, the prior art, the objectives of the claim method, the additional advantages of the method, the knowledge of existence of the involved products, the nature of and the relationship between those products, the degree and the way in which these products would lead to the result, and all this from the perspective of the skilled person. And based on all these circumstances, the Court of Appeal ruled that the patentee had knowingly chosen to claim ruthenium salt and that the use of tempo as a catalyst does therefore not infringe the patent. And the weighing of these factors is left up to the Court of Appeal, and the Supreme Court may not interfere in such factual decisions. The Supreme Court rules that the question which has to be answered is, do, in the perspective of the skilled person, the claims, read in light of the description and the drawings, leave room for equivalence, taking into account, on the one hand, a reasonable protection for the patentee, and on the other hand, the legal certainty for third parties. And I'm quoting from the judgment, the will or the intent of the applicant to renounce such protection does not play a decisive role. It apparently does play a role. This ruling, in my view, confirms that the Dutch approach to equivalent is that of a contextual interpretation of the claim. If this interpretation of the claims do not leave room for equivalence, there cannot be protection beyond the meaning of the claims, which is what Lord Neuberger seems to explicitly rule in Actavis versus Lilly. There is a normal interpretation. This probably means what we think at least the normal purposive claim construction, and there is the question of protection for equivalence beyond the meaning of the claims. As the Advocate General van Persum puts it in his advisory opinion, in the Netherlands, we think we should avoid double counting. And if equivalents are already taken into account while interpreting the meaning of the claims from the perspective of the skilled person, there seems to be, according to the Advocate General, seems to be little room to also protect equivalence beyond the meaning of the claims. And this means that since the new Actavis Lilly judgment in the UK, the Netherlands approach seemed to have drifted away from the approach in the UK and also in Germany, at least from a dogmatic point of view. Another important takeaway from the Bayer-Sandoz judgment is the relevant date to establish the scope of protection of a patent. The Supreme Court rules that in this respect it is only relevant what the patent adds to what is already known in the state of the art. Therefore, the knowledge of the skilled person at the priority date or the date of application is relevant. However, with respect to the question of infringement, the knowledge of the skilled person at the time of the alleged infringement, especially with regard to equivalence, can also be important. And the Supreme Court also leaves the disclosed but not claimed is disclaimed rule untouched. That's important to note in this cassation proceedings. This means that patent attorneys have to be, I think, very careful in drafting patents. If the application discloses a certain product or feature as a possible variant, it should also be claimed. Otherwise, it seems wise maybe not to mention other products or features in your description. This rule also follows from earlier Supreme Court judgments, for instance, in the AGA Occlutech case. If we talk about equivalence, the prosecution history is often a good source of inspiration for alleged infringers. If a patentee applied a narrow interpretation of the claims to secure the patent, he is not allowed to apply a broader interpretation to prove infringement. In such cases, there is very little or no room for protection of equivalence. But how about file wrapper estoppel in the Netherlands? There is still a very big difference between Germany, the UK, and the Netherlands when it comes down to the effect of the prosecution history. In 2006, the Dutch Supreme Court ended a difference of opinion between the Court of Appeal and the Court of First Instance in The Hague. The Court of Appeal held that if the meaning of the wording of the claim, in light of the description and the drawings, is clear, that the alleged infringer cannot refer to the prosecution history, arguing that such meaning which the patentee forwarded during the prosecution in order to be able to secure the patent. The Supreme Court ruled, however, in 2006 already, that this rule only applies if the patentee wants to invoke the prosecution history, but not in the situation where the alleged infringer invokes file wrapper estoppel. So in short, in the Netherlands, alleged infringers are always allowed to use prosecution history if they want to show that the claims leave room for equivalence. For instance, because the patentee limited the claims during prosecution or interpreted the claims in a limiting manner to secure the patent. And if I understand Chris correctly, also after Actavis versus Lilly, it is still rare that one can rely on the prosecution history in the UK, and I learned the same from Christophe today. We have now seen the conclusion from the Bayer-Sandoz case, and we also recapped the effect of the prosecution history in the Netherlands. But what was not yet discussed is how an equivalent is actually established in the Netherlands. When is a feature or a product really an equivalent? And unfortunately, the Supreme Court did not explicitly rule on how to assess equivalence. There's not a strict set of rules or questions which can be applied. And the Court of Appeal and the Court of First Instance in The Hague apply the function, way, result, and insubstantial differences test. And these tests try to establish whether an alternative has essentially the same function to reach essentially the same result in essentially the same way. But how do you assess what is really the same? In his advice to the Supreme Court, in the Bayer-Sandoz case, Van Persum, the Advocate General, states that by applying these tests, he feels that it is always necessary to establish the meaning of the claims in light of the description and the drawings, as understood by the skilled person using his knowledge of the prior art. If not so, how could one, again according to Van Persum, otherwise establish that an alternative in all relevant aspects is the same as what is literally claimed? Before going to our last slide, I want to provide you with a comparison on highlights between the Dutch approach and the UK approach. In the Netherlands, there is only one interpretation, the contextual interpretation of the claims. While applying this interpretation, the question is asked whether, from the perspective of the skilled person, the claim leaves room for equivalence. This at least comes across as being dogmatically different than the new UK approach, where there can be protection for equivalence beyond the meaning of the claims. In practice, however, we feel that this difference could be very small, and both approaches could also easily lead to the same result, but time will tell. Furthermore, to find equivalence in the Netherlands, the function way result test and insubstantial differences test is applied. The Netherlands is not familiar with explicitly asking a certain set of protocol or improver questions to establish equivalence. But surely the answers to questions 1 and 2 of Lord Neuberger are also very relevant for the Netherlands to establish whether the skilled person would interpret the claims to leave room for equivalence or not. And finally, the Dutch court allows an alleged infringer to always rely on the prosecution history. The rationale behind question 3 of Lord Neuberger is, I think, safeguarded in the Netherlands through, for instance, file wrapper estoppel. Then turning to the last slide of this webinar, we have guided you through the doctrine of equivalence as applied in the UK, Germany and the Netherlands. And it seems evident that two very important patent jurisdictions, the UK and Germany, have dogmatically grown very close to each other, which for the UK has been a tremendous change, as we learned today from Chris and James. Although time will tell, we want to provide you with a recap of what we believe to be the most important learnings of this webinar. First of all, as already mentioned, we can establish that the UK and Germany have now a very similar approach to equivalence. There can be protection also beyond the meaning of the claims. This is dogmatically not possible in the Netherlands, where the claims are interpreted within a certain context, also allowing to broaden the technical meaning of the claims by looking at the inventive concept of the patent, or in other words, the idea behind the invention. But in practice, there does not seem to be a fundamental difference. We have seen that the protocol questions or improver questions play a very significant role in the UK and Germany to establish equivalence. These questions, which have to be answered in Germany and the UK to establish whether a variant should fall under the scope of protection, are also very similar in both countries, with only one, but we believe fundamental difference. Lord Neuberger ruled that an inventive variant may also be held infringing under the doctrine of equivalence, and therefore does not require that it should be obvious for the skilled person at the priority date to apply the variant. The German rule is therefore stricter, which has also been explicitly mentioned by Lord Neuberger in his decision. In the Netherlands, however, these questions are not explicitly identified or answered by the courts, but of course the answers to these questions are just as relevant for the Dutch contextual interpretation of the claims. Since the Dutch court is not used to work with these questions, it will not be a surprise that until now the Dutch court never decided on the specific difference between the UK and Germany. But if I have to give you my personal opinion, I expect that the Dutch court would follow the German view on this. If applying the variant would involve an inventive step for the skilled person on the priority date, I think in the Netherlands the claims would not be construed in such a way that this inventive variant would also fall under the scope of the protection. However, all three countries accept that also variants which were not yet known at the priority date, and therefore new, could fall under the scope of protection, but in Germany, and as well as I expect at least in the Netherlands, a new and inventive variant cannot fall under the scope of protection. And I think we learn from our patent litigation practice, in which we represent both patentees, alleged infringers, that, as Christophe already mentioned, the answers to the third question will in many cases, in all three jurisdictions, tip the scale. However, this is also the question in which the UK, German and Dutch court still apply fundamentally different views, which lead to different outcomes. For instance, the UK and Germany opened the door a bit further for file wrapper estoppel, while in the Netherlands the door is already wide open for more than a decade. This difference could already lead to an opposite outcome in our jurisdictions. And then our final learning. The form Stein, or in the Netherlands and in the UK called the Gillette defense, is more likely, this is what we believe at least, is more likely to succeed in the UK and the Netherlands, where it is dealt with as some sort of hybrid validity infringement defense, than in Germany due to the bifurcated system. Squeeze arguments simply work better in a system where validity and infringement are tried within one proceedings. This is the end of our webinar. I learned that we already received some interesting questions. Thank you for that. Since we have reached the end of our slot, I think it's best we will get back to you on those questions by email. I would also like to draw your attention to some of our further resources, such as our newsletters, Transceiver and Synapse. as well as our patent map and global IP index. Our European patents team is happy to share this information with you. Just drop us an email and we will make sure you will be put on the list. Yes, thank you for attending our webinar, and until next time.